Hi, I'm Denise and you're watching Law with Denise. So you've heard of the Hedley Byrne principle and you've heard of the special relationship that was established in Hedley Byrne and Heller 1964. But you're not exactly sure what we mean by the Hedley Byrne principle and you're not sure what we mean by the special relationship. Worry not. In this video, I will explain those two things. By the end of the video, you should be able to understand what we mean by the Hedley Byrne principle, or sometimes principles as you'll see in books, and you'll be able to understand what is meant by the special relationship. In Hedley Byrne and Heller in 1964, the House of Lords decided that in some situations, a claimant will be able to recover damages from a defendant even though they're in a non-contractual relationship. The House of Lords decided that in such situations, if the claimant can identify that the defendant provided information or advice negligently, they may be able to recover damages if certain principles were met. And these principles are what we refer to as the Hedley Byrne principles. The House of Lords outlined when it would be possible for a claimant to recover damages from the defendant when the defendant has given them information or advice negligently, even if they're not in a contractual relationship. And the House of Lords pointed out that recovery would be possible if the criteria laid out in the Hedley Byrne principle, or principles as some people refer to it, were met. Now, what exactly are these principles, or what exactly is the Hedley Byrne principle? The Hedley Byrne principle has four parts to it. Firstly, we need to identify that there was a special relationship established between the defendant and claimant. Secondly, the courts will be interested to examine or to confirm that the defendant voluntarily assumed responsibility towards the claimant. Now, thirdly, the court is concerned with or needs to know that the claimant relied on that advice or information that was given to them by the defendant. And finally, the court wants to know if it was actually reasonable for the claimant to have relied on that information. That is the Hedley Byrne principle. Those four criteria need to be met in order for the court to be convinced that the principle has been met, and therefore for the claimant to be able to recover damages from the defendant in a situation in which there is no contractual relationship, but the defendant has provided them with information or advice negligently. Now, in this video, in addition to that, as promised, I'm going to explain to you what we mean by the special relationship. For explanations on the other criteria that are laid out in the Hedley Byrne principle, please do have a look at the links in the description because I have other videos on those. But let's now have a close look at what is meant by the special relationship. To understand the special relationship, we can look at Lord Reed's judgment. Lord Reed said the special relationship arises when the facts indicate the following. The party seeking the information or advice is trusting the other party to exercise such a degree of care as required in the circumstances, and it was reasonable for them to do that. And the person giving the advice knows that the inquirer is relying on the information, and if they didn't know, they ought to have known. So what does this look like in practice? What this means in practice is that the person that is seeking the information or advice is trusting the other party to provide that information or advice with a certain degree of care. And when we say certain degree of care, we're talking about the certain degree of care that is required in the circumstances, and it is also reasonable for the inquirer to actually expect them to exercise a certain degree of care. So if we put this into context, what we can do is we can look at, for example, the relationship between a solicitor and a client. The client would be the person seeking the information. The client is inquiring. Yes, the special relationship would probably arise in such a situation because the circumstances would normally require the solicitor to exercise a certain degree of care when providing that information. And in most circumstances, we would think it reasonable for a client to expect their solicitor to provide a certain level of care when providing them with information or advice. In addition to what the client or claimant expects and is reasonable for them to expect in the circumstances, the special relationship also requires the facts to indicate that the defendant, being the solicitor in our scenario that we've created, the solicitor knew that the claimant was relying on the information, and if they did not know, and the facts indicate that they should have known, then the special relationship has arisen. So it has quite a few parts to it. One, we want to know that the claimant was trusting the other party to provide a certain degree of care. But it's also important to look at the circumstances, and if the circumstances actually require the certain degree of care that the claimant was requiring or expecting from the defendant, and it was reasonable for them to expect that, that is okay. And in addition to that, what the special relationship asks for is indications that the defendant knew that the claimant was going to rely on that information. And if the defendant says they did not know, if the facts indicate that they should have known, then the courts will usually say the special relationship has arisen. Now, in most situations, we're going to have a professional who is the defendant. But in some situations, we've seen that the defendant is not actually a professional, such as a lawyer or a doctor, but the special relationship can still arise. And if we look at Lennon and Commission and Metropolis 2004, that's an example of it. Now, in this case, the defendant was an employee of the Metropolitan Police, and she had access to complex information. The claimant asked her for information which he needed, and it turns out that in reality, she did not actually have access to some specific information that he needed, but she did not tell him that. The court said that a special relationship had arisen because he, the claimant, was trusting that the defendant would exercise a certain degree of care when providing the information. And the circumstances required this degree of care to be exercised, and it was reasonable for him to trust that this degree of care would be exercised. Why was it reasonable? Well, it was reasonable because he was under the impression that she had access to that information. She did not tell him that she actually did not have access to that information. So because she didn't tell him that, it was reasonable for him to expect a certain degree of care to be exercised when she was giving him that information. And the facts indicated that the defendant knew or ought to have known that the claimant was going to rely on that information. Now, another thing that Lord Reed pointed out with regard to what we mean by the special relationship is that the special relationship doesn't normally arise in social and informal contexts. It normally arises in business contexts. So this means that if you are a professional lawyer or a doctor and you're out at a party and somebody asks you for information or advice, normally if there is a negative consequence after you've given them that advice, liability shouldn't arise because a special relationship would not normally arise in such contexts. We're looking for circumstances which indicate that you knew that you were doing business. So if you're out having fun and somebody just asks you for legal advice, normally, no, the courts will not suggest that the special relationship arose there. However, you may come across the case of Chaudry and Prabhakar, in which a friendly relationship between the two parties led to a duty of care arising. Yes, you will come across this case, but bear in mind that the case has been heavily criticized, and it is very, very unlikely that it will be followed in future. So we can continue to accept that normally the special relationship arises in business contexts. If we want to find a case which helps us to understand or to see how the special relationship arises in the courts, we can turn to Esso, Petroleum and Mardon from 1976. Now, in this case, we saw that the claimant was given information by Esso Petroleum, and the information that the claimant was given was that if he were to lease a certain petrol station, he would be able to sell 200,000 gallons of petrol in 12 months. The claimant leased a petrol station and he was not able to sell 200,000 gallons in 12 months. He was able to sell 78,000 gallons in 15 months. So, did the special relationship arise? Well, the Court of Appeal established that the special relationship had arisen in this case. Yes, the claimant was trusting Esso Petroleum to exercise a certain degree of care when providing him with the information and advice. And the facts indicated that it was reasonable for the claimant to have expected or trusted a certain degree of care to be exercised when he was being provided with the information or advice by Esso Petroleum. And the facts indicated that the defendant knew or ought to have known that the claimant was going to rely on the information that they provided him with. So there you have it, an outline of the Hedley Byrne principle and an explanation of what the special relationship means. Until next time, please remember to like, share, and subscribe. Thank you, and bye-bye.